Today's talk is a little strange, given that the current situation in Lebanon can only be described as total collapse, not only of government, but a way of life. Given this context, the port blast seems like a marginal event, yet there might be some value in examining the developments in the case, not only for the destructive impact of the blast itself, but also because it acts as a microcosm for the dysfunctions of the Lebanese political system. In today's presentation, I will go over the details of the blast itself, the government agencies responsible, and then I will present an update on the status of the investigation into the Beirut port explosion and the limitations of the Lebanese political system to provide redress. Finally, I will close with some thoughts on the possibilities that victims have for redress. Finally, I also want to thank Felicitas and Lucas with the Borderline stream, who greatly helped rein in the scope of this presentation and made it, I think, more watchable. Most of the information in this presentation comes from the Forensics Architecture Investigation, a Human Rights Watch report, the NGO Legal Agenda's Guide for Victims, and Legal Action Worldwide's report on the blast. So the details of the blast. On August 4th, 2020, repairs in Hangar 12 of the Beirut port triggered one of the largest non-nuclear explosions in history. The immediate impact of the explosion led to the death of 218 people, 3 of them children, wounded 7,000, 150 of whom are now physically disabled, and damaged 77,000 apartments and displaced over 300,000 people. The explosion disrupted all aspects of life in Beirut, from schools to health services to infrastructure. The estimate of the material damage, according to the World Bank, is between 3.8 and 4.6 billion US dollars. The UNDP estimates the cost of cleanup at around $100 million. So as for the timeline of events, in 2014, a Russian businessman who is a resident of Cyprus, Grachushkin Igor, bought the cargo ship the Rosis for his first experience in international shipping. He chartered the ship to export 2,755 tons of ammonium nitrate from a Georgian fertilizer company through a company called Teto Shipping, registered in the Marshall Islands. The ship departed from Georgia and flew under a Moldovan flag, and its destination was to a Mozambican explosives company. The company bought the material through an intermediary trading company in the UK called Savaro Limited. Now, I won't touch on the international law of the sea dimension of this talk, and I'd be happy if you would want to elaborate on this later in the Q&A. But I bring up these details because they may be of interest to you, and some of it will be relevant.
If I intervene, the audio is not optimal. Perhaps you can arrange a little bit. I can't hear you so well.
Sure, thanks. Not sure. Is this better?
And perhaps you just slow down a little bit, then it might be easier to follow. Thank you.
Sure thing, sure thing. Okay. Right, so the ship made a stop in Beirut on the 21st of November, 2013. It stopped to take on extra cargo to pay for fees for the passage through the Suez Canal. According to the ship captain and the Lebanese Ministry of Public Works and Transport, this came as a direct order from the ship owner and was unexpected at the time. The ship was then detained by the Beirut Port Authority due to it being judged as unseaworthy. The extra weight of the additional equipment led to the ship hatches to buckle. The ship was also found to have outstanding debts, leading it to be impounded with 4 of the crew remaining on board. Repeated attempts to contact the owner of the ship and the recipient of the cargo were met with no response. The cargo on the ship was only offloaded a year later, in October 23 and 24, 2014. By this point, already multiple officials in the Lebanese government, including at the ministerial level, have been informed that the material is dangerous. Once the ship arrived at the port, it was the responsibility of the Ministry of Finance and Ministry of Public Works and Transport, which oversees the Port Authority. But it's important to note that there are overlapping authorities of multiple agencies at the port between customs, security, military, etc. And this creates a confusing jumble of legal and executive jurisdictions. As far as we know, the material remained in Hangar 12 until it exploded, although there are possibilities that some of the material was stolen to be sold off. Between December 2014 and October 2017, 6 letters were sent to a judge of urgent matters to get permission to sell the material. In each case, the judge told the customs officials that their requests followed incorrect procedures, given that they needed to contact the Ministry of Public Works and Transport. This will become a key point of contention in the responsibility behind the blast. The Minister of Public Works and Transport, the director of the ministry, claims to have sent 18 letters to the urgent matters judge on this issue. In March 2018, approval is finally given to sell the material. The Ministry of Public Works and Transport refuses to pay the inspector assigned to assess the material. In April 2019, a second inspector is sent, but he's not given access to the warehouse, so he's unable to assess the value of the material. In September 2019, agents of state security, which is a different Lebanese security agency, learned about the ammonium nitrate. They completed a final report about the ammonium nitrate and sent it to the state prosecutor on June 1st, 2020. The prosecutor sent an order to fix the deteriorating condition of the warehouse, particularly the doors and the walls. Ironically, it's this attention that is the direct cause of the blast. Due to the poor storage conditions of the bags of ammonium nitrate, the repairs created an explosion. It's worth noting that during this period, Lebanon had 3 different governments in power and a period of 2.5 years without a president and over 3 years without an official government. So it's difficult to come up with appropriate analogies to explain how the Lebanese government functions. But I think one of the better analogies is that Lebanon is a type of oligarchy. After the civil war in 1990, the warlords who were fighting each other in the war were given portions of the government in order to help them to come to terms with each other. This produced a system of elites in collusion with each other who see public office as a source of prestige and venality, and the state serves as a theater for their competition rather than as its own actor serving the interests of the people or acting as an executive. Public political deliberation is rare, and most political decisions are taken behind closed doors through informal consultation, including with foreign powers. So this system was somehow functional, I would say, maybe not by European standards, but since 2015, it has become increasingly dysfunctional even by Lebanese standards. Now to the port, it's basically a microcosm of the logic of Lebanese politics. The port provides massive lucrative opportunities and was the site of major negotiations for the post-Civil War resolution. In 1993, the Council of Ministers divided the Port Authority into 7 seats distributed for each of the main political factions. Again, this reflects the philosophy of politics in Lebanon after the war. Officially, the port's under the Ministry of Public Works and Transport, but there's no actual clear institutional position in the structure of the state. So it's difficult to determine a hierarchy of authority. This setup makes jurisdictional objections to the authority of any government body quite effective, and this has been used in the past to block any investigations into port activities. Despite this confusion, because this is the specific case of the ammonium nitrate in the port, it's actually easier to establish who had authority in this specific case. We can identify 7 and perhaps more main government ministries and agencies that had knowledge of the presence of the ammonium nitrate and failed to act to remove them. By far, the biggest responsibility is to the Ministry of Public Works and Transport, who needed to accurately describe the cargo, followed incorrect procedures to sell the cargo, failed to act on selling the cargo once they had approval, and most importantly, stored and maintained the material improperly. Officials in the ministry had knowledge of the material since April 2014, and all 3 ministers of the ministry knew about the material. More directly, the ministry was responsible for storing the material, and you can see the conditions of storage in the following slide. The 2 left images are the international or the conditions for storage of ammonium nitrate in Australia and the UK. And on the right, we can see how it was stored. Sorry, the 2 right images are the storage in Australia and the UK. And the leftmost image is how it was stored in Lebanon. And on the right, you can see a picture of how the bags were stored. The Ministry of Finance oversees the customs officials who are responsible for selling the material, and they also failed to properly request permission to sell the material. The Lebanese army, according to the Lebanese weapons and ammunition law, is responsible for approving the import of weapons-grade material and is required to inspect any such material. They were informed in May 2016 of the material, but they responded that they have no use for the ammonium nitrate, even though they acknowledged that it could be used to make bombs. The Ministry of Interior oversees the Directorate of General Security, and they had knowledge since May 2014. The Directorate of General Security has an office at the port, and between 2014 and 2020 wrote 5 reports on the ammonium nitrate. Finally, fifth and sixth, I want to talk about state security and the Higher Defense Council, which is headed by the Prime Minister and the President. They learned about the material in September 2019 through an office opened at the port to fight corruption. The current Prime Minister learned about the ammonium nitrate in early June. Various judges, which is why the judiciary appears, also knew about the material but did not follow up on it. So to sum up, no security agency official, port official, customs official, etc., took steps to secure the material. Repeated warnings that the material was dangerous were ignored. Attempts to sell the material were caught up due to procedural irregularities, confusion, and incompetence. And there was knowledge about the material towards the top level of government. Finally, before we move on to the investigation, I want to talk about the Hizballah, Syria, Russia connection. So there's a theory that the shipment was intended to arrive in Lebanon on purpose, and that it was meant to be sent to the Syrian regime to make barrel bombs. An FBI investigation done at the invitation of the Lebanese state on October 7, 2020, which was released in July 2021, concluded that the explosion was consistent with only 552 tons of ammonium nitrate. This is far less than the 2,755 tons that were supposedly on the ship. This conclusion is consistent with the estimates of Lebanese authorities. There's also a French investigation which has not been released yet. Some have argued that the missing material went to Syria and that there's a Hizballah connection to the explosion. In my opinion, this theory is possible, but implausible, since the incompetence of the Lebanese political process is enough of a factor to create such a disaster on its own. Evidence pointing to the Syrian connection includes the assassination of 3 people since the explosion who had information on the warehouse, including a freelance photographer who was the first to take pictures of the warehouse, and a public intellectual, Luqman Slim, who suggested that there was a connection between Hizballah and the ammonium nitrate. Additionally, on September 3, 2020, a month after the explosion, the Lebanese army found 4 tons of ammonium nitrate in another location in the port, and there were fires in the port on September 8 and 10, suggesting perhaps an attempt to get rid of evidence. Finally, a Lebanese investigative journalist found that Savaro Limited, the company mentioned before, is likely a shell company linked to Syrian Russian businessmen who are sanctioned by the US government for working for Bashar al-Assad. And a report by Der Spiegel found that the owner of the ship before Gretschuskin banked with the same bank that was used by Hizballah. Now, evidence against this conclusion is that there was a year-long delay between the ship arriving to Lebanon and it being offloaded, which is quite a slow pace if you're in an emergency civil war and need material to make barrel bombs. Second, experts who spoke to the New York Times and Forensic Architecture argued that the blast was simply an inefficient explosion given the condition of the material as we saw. So not all of the material had to explode, and most of it might have been obliterated in the blast. Finally, the repeated and, in my view, genuine attempts to sell the material during the period suggest that there was a real intention to get rid of the material, and that's its incompetence rather than maliciousness. The last thing I want to mention is that the abandonment of shipping vessels is also a depressingly regular occurrence in international shipping, especially in the Arab world. It's not unusual for ship owners to not pay for their ships when they dock and for them to be abandoned and to leave the crew on board of the ship. Now I want to talk about the legal proceedings thus far to give you a sense of whether it's possible to attain justice through the legal system, Lebanese legal system. On August 5, a day after the explosion, the government launched an administrative inquiry, and in parallel, the military started a military investigation. But ultimately, the investigation was referred to the highest court in Lebanon, which is the Court of Cassation. On August 11, the decision was made to refer the case to the Judicial Council, and the government at the time made promises that the report would be released in mid-November 2020. Now, the Judicial Council is an exceptional court. It's an interesting body. It's exceptional, first established in 1923 under the French colonial mandate period. It's a problematic body for several reasons. It can only be referred cases by the Council of Ministers. It is therefore a court created through political decision. The council also follows exceptional procedures separate from regular Lebanese courts. Its decisions are not subject to appeal, and it can detain suspects without informing them of charges violating fair trial safeguards. Due to a variety of procedural particularities, Most of the Judicial Council judges are in one way or another appointed by the cabinet or heavily overseen by the cabinet. The Judicial Council appoints an investigator. Well, actually, the Justice Minister appoints an investigator only after the crime is known in this case. The investigator is also committed to secrecy until the investigation ends, and this has invited endless speculation and doubt casting about the investigative process. Last thing I want to say is that since 1923, over 250 cases have been referred to the Judicial Council. Most of them are crimes of a political nature. The court famously takes years, often decades, to decide on cases, and in Lebanon is called the graveyard of cases. Moving on from the court, what's the actual process that took place? The judge assigned the investigator, Judge Fadi Souan, to be the investigator in this case. The process of his appointment is opaque, but judging by the fruits of his labor, he gained the trust of the people. He ended up bringing charges against 37 individuals, but only detained 25 mid and low-level officials, 17 of whom are still detained today on vague charges, while the rest are higher officials who enjoy a large number of different immunities. In November, Judge Souan asks Parliament to lift immunity on 12 current and former ministers. The Speaker of Parliament rejects the request based on his own interpretation of the law. But there is some debate as to whether this judge can move forward to indict ministers without parliamentary approval. In any case, this is a classic strategy of delay, as we will see in the Lebanese system. In the absence of response from Parliament, Judge Souan goes ahead and files charges of criminal negligence leading to unintentional homicide or homicide with probable intent against the Prime Minister and 3 former ministers on December 10. This raises the ire of the charged individuals and some other political parties who file a complaint against Souan. Souan is then replaced in February 2021 by Judge Tarek Tutunji. Again, the process of investigator appointment is opaque. Bitar has adopted a different strategy of going through the proper channels to lift immunities, which means that he needs to wait for Parliament. So far, Bitar has proven credible and he's been highly lauded by the legal community in Lebanon, but Parliament has not responded to his request. On August 12, Parliament actually attempted another strategy of creating an alternative probe into the explosion, which required a quorum in Parliament, as a way to replace the current investigation. Most observers recognize that this is a way to exculpate the accused officials. This did not pass, not only due to lack of quorum, but because of popular pressure, including protests and confrontations between protesters and security service members. Lebanon has a very intricate system of immunities with a variety of laws and codes that protect a wide range of civil servants and government officials. Each of these can only be lifted through different procedures, which are generally arduous and time-consuming. So far, Judge Bitar has only successfully lifted the immunity given to lawyers, which has been lifted by the bar associations of Beirut and Tripoli. Parliament has yet to lift immunity on sitting parliamentarians or former ministers. The Director General of State Security has refused to lift immunity on any of the civil servants in the Interior Ministry, and the Prime Minister has not responded to requests to lift immunity on military officials. And it's worth noting that many of these immunities date back to the French colonial period, and there are special clauses inserted to prevent French civil service servants from being taken to court. These overlapping immunities mean that there are multiple levels of obstruction that are possible to stop the investigation. And we haven't even gotten to the trial yet. There are a number of strategies of obstruction, and I've mentioned one, but here you see that the most interesting of these are public attempts to garner sympathy by arguing that an official is being unfairly used as a scapegoat. The picture on the right are posters supporting one of the accused army lieutenants in the investigation. Other strategies are to claim that the investigation is politically biased and is only going against one political faction, to question the proper procedures as to whether they are followed. But most importantly, there's a key strategy of delay. There's a lot of points of friction in the process, which allows the process to take longer and longer. Everybody, of course, claims to want justice, but once individuals are named, that often changes. And yet, so far, at every attempt of obstruction, there's been popular protests and mass mobilization, which have forced the hand of public officials and strengthened the political capital of the judicial investigator. Of course, this is an exhausting process, but it seems to be working. It works both to shame those who are not directly accused from taking steps to further derail the investigation, and it works to ensure that those who are accused cannot use technicalities to get away. At this point, I want to switch gears a little bit and talk about victim possibility of redress. In the days after the explosion, authorities promised that an investigation would be concluded by mid-November 2020. Here we are today, more than a year later, with no official account of the events. This isn't to say that we don't know what happened at the port or the events that led up to the explosion. Investigative journalism has by this point uncovered a detailed account of the events leading to the explosion, and there's a cache of official government correspondence online dating from 2013. Unusually for Lebanon, which is famous for having cases in which there is no factual evidence, no factual evidence emerges, the question isn't whether the truth can be known, but whether the Lebanese political system is capable of providing justice and accountability. The victims of the blast have pursued several strategies to achieve justice, but I will broadly divide them into three. There's a pursuit of the domestic investigation and its support through popular mobilization. There's an attempt to ask help from particular countries, especially France, and through the European Union. And then there's an attempt to create an international investigation through the United Nations. This is a picture of Macron, who came to Beirut I think a few weeks after the blast. And you can see he was very well received. I want to start with the possibility that justice can come from the EU and France. So shortly after the blast, an online petition gathered over 55,000 signatures calling for France to take control of Lebanon in mandate similar to the one that was in the early 20th century. In April 2021, about 100 prominent public figures called on France to sanction Lebanese officials for corruption. Now, towards the end of April, France took action and imposed sanctions on key Lebanese individuals, which included freezing assets, entry restrictions. The EU has followed France's lead, and the EU Council in July put forward a framework for sanctions that has not been applied yet. The sanctions mainly address three broad activities: obstructing or undermining the democratic political process by persistently hampering the formation of a government, obstructing or undermining the implementation of plans to improve accountability and good governance, and finally, financial misconduct and corruption. I have no problem with the third of these, but the first two, frankly, are a little reminiscent of some of the imperial dispositions of European countries in the past. I think these sanctions are going to end up being unproductive for the pursuit of justice in the case of the Beirut blast, but also for reforming the Lebanese political system more generally. The sanctions are status quo maintaining, and they hope to return the Lebanese political system to its normal process. Since October 2019, there have been wide protests in Lebanon precisely against this political system, and these protests have gained quite a considerable amount of traction. The French and EU sanctions end up being counterproductive in enabling such a systemic reform, and they allow officials simply to return to the status quo. It's precisely the normal functioning of the Lebanese political system that produces a lack of justice since the end of the civil war, and a return to it is no solution. The second strategy is a call for an international investigation. A number of NGOs, including Amnesty International, Legal Action Worldwide. Sorry? Somebody's mic is...
Herr Frohwein, stellen Sie sich bitte stumm.
In der Blumenhardtstraße 53, wir trinken hier einen Tee und vielleicht ein Glas Wein, je nachdem. Und
Professor, for Bogdandi, you can silence.
You can silence it too.
No, it's not here with me. I tried it. I can't do that.
Die Straßenbahn, meinen Sie?
You go unmute all. You can. Unmute all.
Ja, das ist doch am Rand. Ach so, ja. Okay, ja, dann ist am besten fahren wir.
I don't have that option here. It comes from my secretary.
Okay, I'll try to go on.
Yeah, go on.
A number of NGOs, including Amnesty International, Legal Action Worldwide, and Human Rights Watch, have called for an international investigation. Amnesty has argued that an international investigation is the only course for justice. Human Rights Watch has argued that the domestic process has no credibility, is under-equipped, and has failed to take action on a number of issues, and has treated the accused in ways that violate their rights. They call for a wide range of changes, but most importantly, Human Rights Watch calls for an international investigation, for the UN Human Rights Council to adopt a resolution for an international independent investigative mission. I'm sure some of you know this process better than I do, but as I understand it, the Human Rights Council can mandate an investigative mission. The conclusion of the investigation could lead to recommendations on measures necessary to guarantee that those responsible are held accountable. The investigations could include other human rights violations. So here's the reason I'm a little suspicious, or I'm not very optimistic about this course of action as well. There's a precedent for an international investigation and tribunal in Lebanon that does not inspire much confidence. In 2005, following the assassination of Lebanon's prime minister, a special tribunal for Lebanon was set up through a Chapter 7 resolution at the UN, Resolution 1757. The Special Tribunal for Lebanon is a hybrid national international tribunal, which was initially made by request of the Lebanese government, but Parliament never ratified it because it was politically controversial. The tribunal promised to bring the rule of law and justice to Lebanon, and one of the core components was that it would strengthen Lebanon's judicial system. But clearly this hasn't worked. The main flaws in the special tribunal lie with the lack of domestic legitimacy in Lebanon. A substantial number of politically relevant parties consider it an externally imposed mechanism that is a vehicle for the foreign policy goals of the United States and also Israel. They have argued that the tribunal exacerbates domestic tensions and ultimately aims at creating domestic unrest in Lebanon. The major political bloc, I guess minor, sometimes major political bloc in Lebanon refuses to cooperate with the tribunal or to recognize it. This has included active efforts to undermine the tribunal's activities. I think most importantly about the tribunal is that its focus on a single crime reproduced a logic in which there's an elevation of political elites apart from the common person, which is to say elites get justice, but the common person does not. In the end, after lengthy proceedings and onerous costs, the effect of the tribunal on the domestic system has been, to put it diplomatically, unproductive. The Lebanese judiciary was never credited with any of its efforts in contributing to the case, and I think over the period since the tribunal existed, it has suffered rather than grown. So to close, it's a little depressing, but what are the conditions under which international intervention might be productive? In my opinion, one of the key hallmarks of the expansion, which makes it unique from other criminal cases in Lebanon, is that the facts are known in great detail. We know the names of the officials, we know which government agencies are responsible, and we know most of the details around the explosion. In the past, most criminal investigations did not benefit from this amount of factual information, which is to say the purpose of an international investigation, which ostensibly is to uncover the facts, is a little redundant in this case. In the STL, Special Tribunal, they never really uncovered the facts to begin with. So the high visibility of the explosion in Lebanon has meant that most Lebanese people have been following the proceedings of the trial or the investigation very carefully. In the process, Lebanese people have gained an appreciation of the limits and flaws in their own judicial system, which has meant that the movement towards judicial autonomy has gained a great deal of support as a result. As such, if there are forms of international intervention that would be productive, I think they should aim at two goals. First, they should aim at the systematic reform of the Lebanese political system by providing exit ramps for entrenched political dynamics, which is to say no return to the status quo. Second, they should support the existing legal procedures taking place in Lebanon. The graph shows this model of institutional change with critical junctures leading to their unique or special points in time that allow for fundamental shifts in structural conditions. And it's perhaps possible to say that Lebanon is going through such a critical juncture at this time. Unfortunately, based on Lebanese history, most international interventions end up advancing the foreign policy goals of the states that are supporting them. What this means in Lebanon is a hyper-focused attention on Hizballah and on terrorism. As we see, the US sanctions mostly come in relation to cooperating with Iran and to terrorism and not to governance. I think a focus on Hizballah is precisely the wrong direction at this moment, given that the country is unified against the existing political system. Attention on Hizballah would only serve to split up this consensus. There's a rare window of opportunity to create or to work with the critical juncture. to begin movement towards a form of government that does not act as a form of elite competition. Which is to say that perhaps this is a unique moment to give the domestic judicial system a chance to prove itself, given the alignment of the fragmentation among the political elite, unity among the population, and the well-known and factually dense criminal charge. Which is why, in my opinion, if there's any chance for a criminal investigation in Lebanon to succeed, it's this one. And it could create the beginnings of a broader reform in the Lebanese judiciary. This concludes my talk, and thank you, everyone.